Here is the interesting case. PAS 4 is issued before MGT 14 filing. It becomes non-compliance and ROC imposed penalty. So when PAS 4 is issued before filing MGT 14, we will see what is the action of the ROC. This is a very recent order, 5th March 2026. 5th March 2026. Which highlights a very common but serious compliance mistake during private placement of shares. This mistake relates to issuing of a PAS4 before filing of MGT 14 with ROC. So many startups, private companies, and even professionals sometimes overlook the correct sequence of filings in private placement transactions. Companies that clearly prescribe a strict compliance order and failure to follow it can lead to penalties under the Companies Act. So there is a clear compliance order. This order, that sequence involves here the case Sweet Karam Coffee India Private Limited, where the ROC imposed a penalty for violation of Rule 14, Sub-Rule 8 of Companies Prospectus and Allotment of Securities Rules 2014. Let us understand the case step by step. Yes, this is the case name. This is the company name. Sweet Karam Coffee India Private Limited. And this company, this is industries, food products and coffee brand. This is Chennai based company. Officer in default also mentioned in the order. This is the director name, officer in default, because the company and director both are penalized. We'll see the provisions, legal provisions. The violation relates to Rule 14, Sub-Rule 8 of Companies Prospectus and Allotment of Securities Rules 2014. What this rule says, a company shall issue private placement offer come application letter, that is PS4. What is PS4? Private placement offer come application letter. This PS4, issue of PS4 only after filing of relevant special resolution or board resolution with the ROC. In a simple terms, correct sequence should be pass special resolution for private placement, file form MGT 14 with ROC. After ROC filing, issue PS4 offer letter to investors. If PS4 is issued before filing of MGT 14, it becomes a violation. Here the facts of the case is, during financial year 23-24, the company planned to issue shares through private placement. Special resolution passed, shareholders passed special resolution on 13th April 2023. For the purpose, 24,706 equity shares to the investors. One investor actually. PS4 issued on the same day, that is 13th April 2023. The company circulated private placement offer letter PS4 for 2,500 equity share to the investor because in tranches. This means the company offered shares immediately after the resolution on the same day. Critical compliance was missed. MGT 14 filed later, that is on 2nd May 2023. So what happened is 13th April special resolution filed, special resolution passed, not filed. Special resolution passed on 13th April, PS4 issued on 13th April, but 2nd May MGT 14 is filed. This is incorrect sequence under Rule 14, Sub-Rule 8. PS4 must be issued only after filing of MGT 14. This is a violation. The company circulated private placement offer letter before filing of the resolution with ROC. This resulted in violation of Rule 14, Sub-Rule 8 of private placement rules. Since the Act does not provide a specific penalty for this violation, the penalty was imposed under Section 450 of the Companies Act 2013. ROC issued show cause notice on 31st December 2025. Company responded stating the default occurred inadvertently. There was no intention to violate the law. Requested lenient consideration. An e-hearing was conducted on 19th February 2026 where a practicing company secretary appeared and made submissions. Company also submitted GNL 3 forms designating officer in default. Penalty imposed by ROC after examining the facts. The ROC imposed on the company 10,000 and the officer in default 10,000. Maximum penalty limit mentioned in the act. That is the company, if you see maximum penalty limit up to 2 lakh. Officer in default up to 50,000. But here imposed is 10,000, 10,000. Considering the circumstances, ROC imposed a minimum penalty. Order also directed to pay the penalty within 90 days. Should be through EA adjudication portal from their director from their personal fund, his personal fund. Right to appeal provision is there before RD within 60 days through Form ADJ. This order teaches the several important compliance lessons. Always follow the legal order. First board meeting, then special resolution, then file MGT 14, then issue PS4. Receive application money, file PS3. If PS4 issued before MGT 14 filing, it becomes non-compliant. Private placement involves multiple forms, multiple filings. These PS4, PS5, PS3, MGT 14. Any delay or wrong sequence can attract penalties. And professional certification is important. Even private startups must comply with Companies Act, private placement rules, ROC filing requirements. Non-compliance may impact future funding rounds and investor confidence. We have two channels, RR Corporates and other channel, RR Legal Talks. Please do subscribe, hit the bell icon so that you will not miss any of my latest videos. Thank you.